Hi everybody. As Fergus said, I'm Simon. I'm a PhD researcher in energy law at KU Leuven. I look at peer-to-peer electricity trading from a legal background. And I focus on Belgian and Dutch law, but for this presentation I will zoom in specifically on Flemish law. So Flanders is a region of Belgium. And the subtitle I've given to this presentation already announces what I'm going to say. It's about some practical delays after a delayed legal framework. So it was already mentioned in previous presentations, but I just want to quickly remind you of the types of legislation that we need in order to roll out peer-to-peer electricity trading in practice. So starting from the top left side, as you know, peer-to-peer trading is laid down in the second Renewable Energy Directive, which was enacted in 2018 and should have been implemented by the end of June of last year. And for Flanders, we see that specifically the legislative act was adopted in April, so still on time. But the further implementation, which was essential to putting it into practice, was only enacted in the following months. So I just want to stress here already that once you cross the deadline of the 30th of June, then you're already in a problematic situation with regards to your compliance with EU law. So just to make clear that the directive is not an option. I mean, there is a really strong obligation under EU law to implement this. And secondly, this implementation should be effective. So that means that you cannot just enact legislation and then market actors will deal with this. No, you have to make sure that this right can be exercised concretely in real life. So this clock starts running from the 1st of July, let's say. And so the issue that I'm going to discuss in my presentation today revolves around these implementation measures that were undertaken by the Flemish government. So I have some snapshots from the different legislative acts that are required. So first we have the directive, then the decree, which can be compared to a law, and then you need an executive measure from the government. And so what is enacted in this, or in the draft of this executive measure from the government is a step-by-step approach. So they realize that moving to peer-to-peer is really a revolution in the electricity landscape, and so we will do this gradually. And so you see that there are three types of acceleration that they envisage, namely the year 2022. So this year we will just get going slowly, then the next 3 years or 2 years we would start accelerating, and then we would go on full speed by 2026. Coming to the material content of these provisions, it was foreseen that peer-to-peer between more than one or with more than one counterparty, so more than two, then you would just be considered to be a supplier. So in that case, there's no specific possibility for you to engage in peer-to-peer trading, if you are just an individual. The supply requirements, the requirements imposed on the suppliers are way too high. So this is not something that is really feasible for average household users. But there is an exception for peer-to-peer sale of green power, where if it happens one-on-one, so between individuals, the supplier regulations do not apply. So this, I put the check mark because I discussed it, and we will zoom in more on this second case. So as I mentioned already, from 2026, this would be completely opened up. And so it would happen between two active customers with relation to green power on the distribution grid. This is because the Flemish government is only competent to regulate distribution power or the distribution level. And the peer-to-peer sale occurs within the same quarter hour, because this is the imbalance settlement period. And the maximum of this peer-to-peer sale is limited to the offtake of the receiving peer. So this is the most elaborate scenario that they had envisaged from starting from 2026. And in the intermediary period, we would start slowly with some more restrictions. And these restrictions entail that the active customers must have the same supplier. Then, of course, it's a lot more, it's a lot easier for the supplier to do this on an accounting basis, obviously, because he is just moving volumes from one to the other without being imbalanced as such. And another technical limitation was also imposed, namely it was the green power will be produced by PV with a certain technical limit. Imbalance settlement is the same, so the quarter hour. And you can only have one contract active at the same time, so you have to keep trading with the same person. Now, the question then is this effective implementation of EU law in the meantime? Because as you remember, the clock stop is running 1st of July, and only by 2026 we would have the full implementation. You can even ask whether the full implementation of 2026 was already in compliance with EU law. But then a little saga followed basically between three important actors. So we have the government of Flanders, which is responsible for drafting these executive measures, putting into implementation peer-to-peer in practice. Then you have the energy regulator, the FREC, on the right-hand side, and the DSO for Flanders, Fluvius. And so when this draft came out in July of last year, July 21, with the content that I've described just now, with this step-by-step approach, the FREC, so the Flemish regulator said, yes, of course, we understand that Fluvius, this is all going too quickly for you, and you did not know that the directive was coming in 2018, so we're only 3 years later, so this is going way too fast for you. So we understand that the practical implementation is difficult and you need to adapt your processes, but I mean, this situation is illegal under EU law, so we cannot validate this. Okay, this is already a problem for the Flemish government because they have a real clear negative advice, but they still adopt the executive measure because they say, oh yeah, but this is just one type of interpretation and we have a different perspective and no problem. But then, once the executive measure is adopted, we go to another, this file is transmitted to another important actor, and that is the Council of State. And the Council of State is really an authority that checks whether legislation is really is in compliance with the Constitution, but also with EU law. And of course, this Council of State confirms in October that this is illegal under EU law. I mean, this was clear to me already. It was already announced by the regulator, and now this this important entity that enjoys a lot of soft power in the legislative system in Belgium confirms that this is illegal and you cannot do this. So now the Flemish government is, realizes that they cannot ignore this anymore. And so by December they say, okay, never mind this step-by-step approach, we will comply with EU law immediately, starting from 1st of January of next year. So there, in less than a month, Fluvius has to adopt all its processes which were prepared based on this step-by-step approach. But the government says, yeah, we don't like this illegality of EU law, we can get a fine for that, so maybe try to avoid this. And so they scrapped this executive measure that they had planned, and from the 1st of January of this year, peer-to-peer should be rolled out completely without any limitations. Yeah, obviously Fluvius is not ready for this. And they say this is impossible for us, first to say that we get some time to adapt. Now you pull out the carpet from under us, this is impossible, there has been a public consultation, this has taken months, all this work is now outdated already, even before it goes into force. And so they say what we can offer is this. We can have peer-to-peer electricity trading by the 1st of January of this year for customers in the same building with the same supplier. So then we can manage the issue and we can just gradually learn, develop our processes or operational management and adapt protocols to this. And we can have some experience with the issues that arise. And they also promise that by the 1st of July of this year, the requirement of being in the same building will be dropped, and energy peer-to-peer trading will be possible if the peers have the same supplier. But obviously, this is still not complying with EU law, but it is a bit more compliant with EU law. And so the energy regulator is asked whether this is okay, this protocol with these concessions that they make, and they say yes, okay, again, we understand the reasons, you're not ready, but please make sure that for the 1st of July, at least what you promised is there. Yeah, I mean, from my cynical tone, you can already expect that by the end of June, Fluvius was not ready. And so when the protocol is adapted, and again, put to or communicated to the energy regulator for approval, they say yes, of course. Now there are fewer requirements necessary, so you are on the way to implementation, but still you're not there. So you have to try harder. And so, because now the regulator is getting a bit fed up because we already we're already 1 year behind the EU law, so the lion starts roaring a bit, and they say we will give you a sanction of 1,000 euros per day of delay because energy customers cannot enjoy their rights, and we need to have this market operational as soon as possible. But then again, we also understand Fluvius. So we will have this sanction start from the 1st of February next year. So you see that the lion is only a kitty that is the rest of the lion. And so what is still not possible currently now in Flanders is energy sharing within an energy community is still not possible, and peer-to-peer sharing is not possible if you have a different supplier, if the two peers have a different supplier. And so if we are counting from the day that the full implementation should have occurred, and we count to the 1st of February, that's already 20 months. So I'm hoping that they will really impose the penalty. Of course, I suspect that now Fluvius will really start counting the costs and maybe anticipate a bit. And so by 1st of January of next year, which is only a few months from now, the peer-to-peer should be possible completely in compliance with EU law and should be rolled out. So even if they are not ready on the 1st of January, you get a month extra because the sanction only starts on the 1st of February. So to me, this seems as a lot of leniency from the regulator with regards to the DSO, which is, in my opinion, very slow. And actually, the DSO was saying, "Oh no, but we are being agile in our implementation." So they had some really clever managers saying that if you do not do what you have to do on the regulation, then that is being agile because you learn as you go along. I think this is a bit cynical. Of course, they had some good lawyers maybe as well, so I would invoke this too. And so to provoke a bit, I say that if it's not bad faith on behalf of the DSO, then at least it's incompetence. If they cannot manage to put in place these protocols more than a year after the deadline has passed. So then there was already 1.5 years that the directive was in place, but they give you time to adapt, and still you need more time. Then I think we have a serious issue. And so with regards to bad faith, I don't have a really clear evidence or like a smoking gun that the DSO is intentionally delaying this, but almost by coincidence, this is something that is really working out for them. And you can draw a parallel with the introduction of the capacity tariff. I mean, there they also were not ready, and so also not in favor of having this capacity tariff. And so it was delayed already twice, and also it should start on the 1st of January. Of course, now we have an energy crisis. And so I think they are also always very happy when a crisis occurs. First they have Corona and now an energy crisis, so probably they can drag their feet a bit more. This also reveals, to me at least, a very important tension between politics and the regulator. So when I showed you this triangle of the most important actors, I think that Fluvius and the politicians, or let's say the Flemish government in general, are really acting together in this field, and the regulator is a bit hesitant to really bite. So I showed that they were roaring, but still it looks more. It's not really a line you should be afraid of. And so I think even this is the first time that they impose a penalty for non-compliance with the regulation. So step by step, maybe they are now growing into their role of making sure that this market develops, because it shows that the DSO has a very important role, and this is just the beginning of the energy transition in general, but more specifically the implementation of the clean energy package. And so it's very clear that the regulator will play a very important role in guiding these new market processes and really enforcing them as well, as we see that the DSO is quite hesitant in Flanders. Now, I would quickly, to compare with other regions in Belgium, I would quickly like to mention the situation in Brussels and Wallonia. So in Brussels, implementation has gone quite well, I think, and it is made possible in the legislation already, and even, I believe, last week, the regulator has enacted a specific tariff for peer-to-peer, which is adapted according to the grid topology. So this means that if you are peers, if the peers are trading on the local grid and they are behind the same feeder, for example, then a coefficient is applied to the tariffs, and this ranges on your distance that you use the grid, and in the closest situation, your grid tariff is reduced to 0, and then you have a half reduction, and then just a full application with regard to the distribution tariff. So often in my research I've seen this, that Brussels is really, the regulator is really thinking ahead, very innovative, and so we see some interesting examples there. Already they also had, with regards to energy communities, they had some sandboxes regulatory sandboxes that were really successful, so we see great support in that region. Now in Wallonia, the situation is a bit on the other end of the spectrum, let's say, since they are lagging behind already in the legislation. So the legislative act was adopted in May in Parliament, and so usually when a legislative act is adopted, it has to be published in the official bulletin, and then it is publicly known and it enters into force. And for the first time in my research career, I encountered that it's not published. So they adopt it in Parliament, but decide not to publish because they were not ready with executive measures. So this is really, I don't know how you call it, but like a cardboard implementation. So yeah, the law is there, but it's even not published. So it does not enter into force. Your rights are even not there on paper, and they say this is because the executive measures are still pending. So for Bologna, the situation is also very complicated. So this brings me to my end to the end of my presentation. I decided to keep it quite non-legal or discussing a bit more the law in the books versus the law in action, as we call it in legal research, showing how as a legal researcher I look at more than just the black letter law, and also look at how this occurs in practice, also looking at the non-strictly legislative factors such as the regulator. And I hope this my presentation also shows to people from a non-legal background that the DSO has an important role in enabling these market processes, and that it's more than just an engineering partner, let's say. So the days that it was just the technical managers are long behind us, I think, and I argue that we should really be cautious when dealing with the DSO, because they have their own interests. And so on that note, I conclude my presentation.